I'm Bruce MacFarlane. I started the practice of law as a federal prosecutor in Canada, and then kind of moved up the system and became the head of prosecutions federally for all of Canada. And then and I'll be describing over the next little while exactly what happened. But before I get into that, I wanted to thank the organizers for inviting me to come to New Zealand. I have been in this wonderful country twice before, both times with my wife, and we actually fell in love with the country and started to think that maybe we should move here. And we started looking at places. We looked at Christchurch and we looked at Napier. And then we started thinking, this is going to be a long trek back to babysit the grandkids for an evening. So it didn't work out. And as well, I almost died in New Zealand when I went on the jet boat at Queenstown. So I feel a connection to the country, and I'm delighted to be back here. What I'm going to talk about today is the causes of wrongful convictions, some of which are invisible. And that poses problems for everybody within the justice system and outside of the justice system. When they're invisible, it has to do with the way that humans interact, the way that they think, their attitudes. So I'm going to talk a little bit about the invisible causes, and then I'm going to move into what I call the immediate causes, the specific causes that are a bit more visible, with particular emphasis on jailhouse informants. I have some experience with jailhouse informants that I'd like to share with you, and I have specific recommendations for New Zealand when it comes to the handling of jailhouse informants, because in my view, they are probably the most dangerous witness that could ever go close to a courthouse. And New Zealand has had some experience with that over the last number of years. Canada has as well as the United States, as well as Australia. So it's a looming and serious problem that needs to be addressed directly. And that's why I'm so very happy with this conference, because this is the way you get change going, is to talk about it openly and candidly. I've been invited to meet with the Minister of Justice for New Zealand on Tuesday, and I'm delighted to be able to do that. If government is prepared to listen and act, that will go a long way to minimizing the risk of wrongful conviction. As part of my career, I'll maybe fast forward to the last little while. Around the year 2000, in that vicinity, I experienced some allegations of wrongful convictions. I was the Deputy Minister of Justice for Manitoba, and we looked into it, confirmed that there was in fact a wrongful conviction. And what we did, when I say we, the royal we, the government, I'm not a politician, I'm a lawyer, but we called a public inquiry into what happened, asking a commissioner who was a retired judge of the Supreme Court of Canada, a wonderful choice, and asked him were there systemic forces at play in this case that caused this terrible wrongful conviction. And he reported back, and he said, yes, there were, and here they are. And he gave a very detailed report saying, you've got systemic problems in this province and in the country, and here are some of the solutions. And he set out a blueprint of solutions. Then we had another one, couple of years later. An alleged wrongful conviction, which we looked into, confirmed that it was a wrongful conviction. And we did the same thing there. We called a public inquiry, appointed a commissioner who was a former chief justice in another province, so he was totally independent, and asked him on this occasion, because in the first we asked were there systemic forces at play. In the second one, we decided to approach it differently and asked him to look at the conduct of those involved, the prosecutors and the police, and asked him specifically, did the conduct of the prosecutors fall below the standards expected of prosecutors? And what about the police? Did they mishandle the case? And the answers that he brought back, again in a detailed report around 200 pages, was yes and yes. Yes, the standards were breached by the prosecutors, and the police did mishandle the case. That's when I became very concerned about the state of the criminal justice system. What I'm going to be talking about in broad strokes today is this. I taught a course called Prevention of Wrongful Convictions at the university for 12 years. And I always started my classes by making this point that generally speaking in law schools, what students are taught is how the legal system works. And what we're going to talk about in this course and what I'm going to be talking about here is how it doesn't work, how it falls apart, how it comes off the rails. The traditional way of thinking throughout the Western world is that wrongful convictions just didn't happen. There's too many safeguards in place. And if a case goes off the rails for whatever reason, it was just a mistake in that particular case, there's no reason for panic. What changed was the emergence of DNA, which showed clearly in a number of cases that in fact there had been a serious miscarriage of justice, and science established that. As a result of my experience that I just described to you in those two cases, I decided to do some research on what was happening throughout the British Commonwealth. Not every country, but I looked at the United States, New Zealand, Canada, UK, and Australia, and what I found was startling. I was quite taken by it, and that is the causes of wrongful convictions in all of those countries are the same. How can that be? It's not just one-offs. There's systemic forces at play in all the countries that have a totally different legal system, a different political system, different social norms, and yet the same causes. I also found that in general, this is not a situation where people are being framed. Rather, there's procedures in place within police services and prosecution services that are creating these problems. And more importantly, there's an attitudinal problem that seems to pervade all police services and all prosecution services. Now, how do you change that? It's rare that there's a single cause of a wrongful conviction, but rather when you look at the list over here of the causes of wrongful convictions, it's a lethal brew of a series of causes, and that's the phrase that's used on the green board over here, a lethal cocktail. And under each of those cases over there, the cocktail of causes is listed. It's very helpful. One of the points I think that's really important to note is that when we're talking about solutions in, for instance, the healthcare system, they're very expensive. If you want to get a bunch more MRIs or research done, that's very expensive. The solutions when it comes to this particular problem, namely preventing wrongful convictions, doesn't cost anything. In how many spheres of our life can we say that solutions don't cost anything? Because it's all about the way that humans handle their cases. The criminal justice system is made up of people, right from the beginning to the end, starting with the police, the prosecutor, the defense lawyer, the judge, the jury, the parole system. They're all exercising judgment and handling cases in the way that they've handled them for years. And the challenge is to change that. And it's all about raising awareness as opposed to plugging more money in. There's two broad causes of wrongful convictions. One is what I refer to as predisposing circumstances, and the second is more immediate causes. And I'll explain what I mean in just a second. Predisposing circumstances, that's the environment and the way that society operates and people operate, which sets us up to fail. One of the most serious ones is pressure to charge and pressure to convict, coming from the public and media. If you have, as an example, a young girl that was murdered brutally, the pressure on the police to solve that case is immense. And with each passing day, the pressure intensifies. And the police start to feel that. And at a senior level, the senior police will say, look, you got to bring this to a conclusion. You're now in your second month. You haven't laid a charge. Get on with it. That's the sort of discussion that takes place. We've got current crimes that are happening today, tomorrow, the next day. We got to get onto those. You can't be fiddling around with a case from 3 months ago. So the pressure intensifies within police services. And similarly with the prosecution service, the burden of proof on them is very high. It's proof beyond a reasonable doubt. And the prosecutors know that they have a high burden to meet, and they're anxious to get whatever evidence they can to support the charge and to overcome that burden of proof. And that might involve calling a jailhouse informant. The second type of predisposing circumstance involves a situation where an accused comes from an unpopular or marginalized group. And in practical terms, across the Commonwealth, that has included Indigenous persons, blacks in the United States, Irish in the UK, who suffer from stereotypes. And so they're immediately suspect. And where they're charged, there may well be, and often is, a practical shift in the burden of proof. That is to say that the jury will not be focused on the fact that the burden is on the Crown, but will start to say things like, well, he didn't testify at the trial. He doesn't have an excuse. So the burden shifts over to the accused, suggesting that he or she is responsible for showing innocence. That's not the law. The law is that the Crown has to show it, but there's a practical shift in the burden of proof. The third predisposing circumstance is what I refer to as cognitive distortions leading to tunnel vision. I'm not a psychologist, but I dug into the world of psychology trying to understand better whether there was explanations for what was going on. Tunnel vision is now part of our language in the legal profession anyway, and perhaps more broadly. That is a premature focus on a selection of evidence and filtering in evidence that will build a case, and at the same time ignoring other evidence that might tend to disprove. You're focused On an individual, you got a bit of a case. It's not really, doesn't really show anything, but you say, he's the best one that we've got in the lineup of suspects. So let's build a case against him. That's tunnel vision. And it arises all the time in all the countries because of the pressure on the police to charge. Let's build a case against that guy. It's not a judgmental concept in the sense that we're saying that a police officer or a prosecutor is a bad person, but rather the pressures, the emotional pressure, the legal pressure, the mental pressure to move forward and charge and convict is immense. And it ends up distorting decision-making at many stages. But what I did find when I started poking around in the field of psychology, these principles that I'm describing to you are well known in psychological circles. They've been around for a long time, they've been studied, they've been confirmed, they're well known, but they're not well known in the legal profession. And that's one of the things that I've been trying to do in some of my speaking and writing, is to start to raise this within the legal profession so that we can catch up to the field of psychology. When I say distorted decision making, I've seen that over and over again. Normal, experienced, otherwise ethical prosecutors who just make bizarre decisions. And how can that be? It comes from the field of cognitive psychology. That's where I found the answer anyway. One is confirmation bias, the tendency to seek, recall, and interpret information that supports rather than refutes an existing belief. That is to say, you've got a case, you've got a theory, you believe in the guilt of the accused, then something comes along. It looks like it's new evidence, and you say, no, that doesn't fit in, and you ignore it. I've seen that over and over and over again, and it comes from the way that humans operate. Paul Simon, many of you will know Simon and Garfunkel. Paul Simon put it simply almost 50 years ago in a ballad, which is often labeled as his masterpiece. It's a song called The Boxer. And one of the lines is, all lies and jests, still a man hears what he wants to hear and disregards the rest. That's Paul Simon's way of describing confirmation bias. The second cognitive distortion is belief perseverance, the tendency to adhere to an existing belief, even in the face of new information that undermines that. That is to say, you've got your theory of the prosecution, the evidence, you believe in guilt, and you can't let go. Even with new evidence, you can't let go. So in one of the, I'll be dealing with this in a second, in one of the public inquiries in Canada, the prosecutor believed in the jailhouse informant, believed what the jailhouse informant had said about the accused, and then DNA came along and showed that the jailhouse informant flat out lied, but the prosecutor, even in the face of that, couldn't let go, and he said, I still believe that he told me the truth. I still believe that his testimony was true. A clear example of belief perseverance. The commissioner who oversaw the public inquiry said it was tunnel vision in the most staggering of proportions, because DNA had clearly shown that the accused had not done it. And then there's the reiteration effect. That often arises in groups where the prosecutors will get together and talk about the case, talk about their theory, and they talk about it so much and repeat it so much that they can't understand any other theory. The confidence in the truth of the assertion is increased the more it's repeated. So the more you repeat it, the more you believe it. What are the practical consequences of tunnel vision? And in my view, based on everything that I've seen and experienced, it means that well-meaning, experienced and competent prosecutors and investigators end up making distorted decisions that affect how the case is handled. That occurs in just about every case. And you look at it with the benefit of hindsight and say, how could the prosecutor have made that decision? That's bizarre. But it comes from these cognitive distortions, which at the time made sense to the prosecutor, but later on make no sense to anybody else. And the practical problem is that the distortion was invisible. Even the justice system participant, the prosecutor or the police officer, didn't realize that they were the subject of these cognitive distortions. They thought that they were just acting normally. What do you deal? What are some of the concrete examples of what I'm talking about? And I've listed some of the examples from the cases that I've looked at across the Western world. It's not just Canada or New Zealand, but rather broadly. Important evidence is not disclosed. The Crown ends up relying on manifestly unreliable evidence, such as jailhouse informants. There's a tendency to ignore new evidence that casts doubt on the theory of the prosecution, and they can't let go of that theory. And sometimes the case is argued on a basis that's not supported by the evidence. In one case of a murder of a young girl, the prosecutor, apparently as a desperation move, developed a theory of a sexual assault before the murder. There was not a particle of evidence to support that, and yet he put it forward. And there was some suggestion, he denied this, but there was some suggestion that he felt so strongly about prosecuting this accused so fully that he developed a theory of sexual assault so that he would have a rough time in jail. Talk about a distorted decision. Given some thought to steps that can minimize the risk of these invisible causes, the predisposing circumstances, and they're few and far between, I have to say that. They're tough because these causes are deep, deep in the psyche of people. It has to do with the way that people think, and the way that people act, and it's deep-rooted and probably was acquired as a young child. So how do you deal with those things? Based on all the cases that I've reviewed in my own experience, I think that there are some things. It's not hopeless. The first is to adopt a test that I personally used throughout my career. I call it the Royal Commission test on all major decisions. And it goes like this. If I was faced, when I was Deputy Minister of Justice, if I was faced with a tough decision, most of the decisions are made behind closed doors. And so you've got to think more broadly about what's the right decision, not the easiest one or the cheapest one, but what's the right decision. And what I always said to myself was, okay, you've arrived at a decision, a tentative decision. How would you feel about explaining that to the public at a Royal Commission, under the glare of lights, with the video camera rolling? How would you feel about explaining it publicly like that? Because right now you're behind closed doors in your own office. And if the answer is, ugh, I wouldn't want to have to explain that publicly, it's probably the wrong decision. If the answer is, I'd be fine with it, I think it's a principled decision, it's the right way to go, then that's more likely to be the right decision. So the Royal Commission test, I have to say, served me very well, and I always relied on it. The second is to develop a contrarian in the case. Draw someone from outside of the investigative team or the prosecution team and ask them to push hard against the prosecutors or the police and ask questions and push really hard. Why didn't you do this? Did you check this? Why not? Have a contrarian who asks all the tough questions to make sure that all of the angles have been covered. The third one is similar to the second, and that is to develop and present defense-based counter-arguments. Have a prosecutor develop an approach that the defense will probably develop and see how it fares. If the defense arguments are too strong, then you either handle the case improperly or you got to do more work. Fourth is to bring in outside advice. I'm a strong believer in what I refer to as fresh eyes. If you get too close to a case and you start to believe in it too strongly, bring in fresh eyes, someone who can assist you and see the case in a different light. And finally, and this is an obvious one, but it's not done that often, and that is to develop a culture of fact verification. You've got a certain fact that you believe you can prove in court, but get out there and get more evidence to support that fact. The fact verification process can be very helpful. It does call on other resources, and sometimes that's a problem. Trying to get someone from another jurisdiction is tough to do, but that's the blueprint that I've developed to try to deal with these predisposing circumstances. None of them are by themselves going to overcome these predisposing circumstances, but that they could help minimize the risk. So that concludes my views on what I refer to as predisposing circumstances. I'm going to move into the more immediate causes of wrongful convictions. And in my view, the top four, there's probably, well, you got the list there. There's many. But the top four, in my view, across countries, including New Zealand, are, first of all, unreliable witnesses, in particular jailhouse informants. Secondly, eyewitness misidentification. Thirdly, unreliable scientific evidence. And fourthly, what's referred to as false confessions, something that most people have a hard time understanding. Why would someone confess to something that they didn't do? But people do, often because they're trying to shelter someone else. But those are the four top causes. They're not the only ones, but they're the ones that give me the most grief. It does vary a bit from time to time, from decade to decade, from country to country, but those are the ones that seem to emerge from Australia, New Zealand, the United States, Canada, and the UK. I'm going to deal with the first two, that is, unreliable witnesses and eyewitness misidentification. Might have trouble, because of time, getting to the second one, but I will try to get to it. I know that the issue of unreliable witnesses and jailhouse informants is very topical in New Zealand at the moment, and for that reason I want to make sure I deal with that reasonably fully, because it was argued in the Supreme Court of New Zealand just a week or so ago. So it's a front burner issue. When it comes to unreliable witnesses, I think it's important to start with basic principles, and please bear with me because these are basic principles. The burden of proof beyond a reasonable doubt, is the highest burden known to our legal system. And that proof beyond a reasonable doubt applies to each and every element of the offense. And every police officer and every prosecutor knows the burden that rests on them. And all of their decisions are designed to overcome that burden of proof. And as I've endeavored to outline, that pressure on prosecutors and police sometimes leads to distorted decisions with a view to success. As one judge famously said, the Crown can't always rely on the local parish priest to prove its case. Sometimes it is necessary to call thieves and drug traffickers to prove the charges, and that's true, and I accept that. It's a necessary part of the burden of proof and dealing with the burden of proof, sometimes you have to call a thoroughly unsavory individual, often because he was there at the time. Why are unreliable witnesses called? Some were there when it happened, as I just mentioned. They were right there at the time of the assault or the murder or the drug trafficking or whatever it was, actually saw something, and they gave a statement to the police, and they're now being called as a witness, even though they have a criminal record. Some took part in the offense and are now cooperating with authorities. Some have some sort of relevant evidence. They live down the street, but have terrible backgrounds, and the Crown needs to call them even though they have a terrible background. Some claim that the accused might have said something offhand that is now relevant, and now they have to be called to relate that to the jury. And the final one, of course, is some are jailhouse informants who are willing to provide what the Supreme Court has said, has characterized as cellmate confessions. That's a special type of evidence that I really want to focus on sharply, because it's quite different from the other categories on the screen. And often it's made up. What does an unreliable witness add to the case? If you can believe the unreliable witness or jailhouse informant, it fills in gaps in the Crown's case, if you believe them. And that's the task of the jury. It sometimes provides insider information as to what was going on in discussions, what was going on behind closed doors amongst conspirators. But when it comes to a jailhouse informant, the third point that I've listed there is what attracts prosecutors. It provides a broad narrative. It provides the big picture. It provides evidence of what happened at the beginning and all the way through to the end in a way that a prosecutor can't prove. So a jailhouse informant who says that he's got a confession is very valuable to a prosecutor because he or she provides that big picture. But the dilemma that arises is, does reliance on a jailhouse informant lead to inadequate police work? And to put a firmer point on it, does it encourage investigative laziness? In other words, if a jailhouse informant puts his hand up and says, "Did you know that he confessed the crime to me?" and there's no other evidence to support that, that's maybe going to be seen by the prosecutor as an easy way to prove the case. Whereas it might be better to say, "I don't believe you," turn to the police and say, "Go and do traditional good police work and enhance the case. I don't want to call this fellow." And I'm jumping ahead a little bit here, but that has been the experience in Canada. I'm kind of giving, this is a spoiler alert, I guess, but the pool of jailhouse informants in Canada has totally dried up. They're not called anymore. The police are doing good police work. They're going back and digging and digging and digging. And the result is a better case. These are better cases that are going to court now that we're not relying on jailhouse informants. There's a moral to that story, obviously. I'm going to focus on jailhouse informants now. I've characterized them as the most dangerous of all witnesses, and I believe that that is the case. There is no more dangerous witness that goes near a courtroom than a jailhouse informant. And I'm going to comment on developments in the United States, Canada, Australia, New Zealand, together with conclusions, options, and recommendations. I'd like to leave my comments with some fairly concrete recommendations, a bit of a pathway to deal with this. So I'll deal first of all with jailhouse informants in the United States, because that's where it all started. That's where the controversy first arose in 1989. And what was happening, it's incredible. A fellow by the name of Leslie White, who was an inmate, came across a process that worked for him. He would pretend that he was an investigator. He had access to a phone, and he'd phone over to the precinct and speak to administrative people there and say, what about that Smith case? It's going to court tomorrow, and can you give me a rundown on the case? So the administrative person would give him a rundown on the case. Now he's got the facts of the case, and he'd start to concoct a confession that never took place. He made it up. He'd speak to the district attorney and say, look, the inmate confessed the crime to me, here's what he said. And the district attorney would listen and say, whoa, that has the ring of truth. And Leslie White did this over and over and over again, and there was a huge blow up in Los Angeles. In 1993, an appellate court made an impassioned plea to prosecutors and said, in essence, prosecutors, you're the ones that determine what witnesses are called. You've got to take a really close look at who you're calling, and if it's unreliable, don't call it. That was in 1993, and things haven't changed that much. 2002 report to the Illinois governor who was in the report warned to restrict the number of jailhouse informants that were being called. So now there's a bit of a movement that's starting up. And innocence projects started to emerge, research started to emerge, and jailhouse informants have played a role in 159 exonerations to date. That's a lot of people. And all of those involved jailhouse informants. There's a recent movement in the United States, and by recent, I'm talking about the last couple of years, to turn up what I refer to as the pretrial microscope on jailhouse informant testimony, involving quite a number of states, and it generally involves requiring disclosure of all deals hatched with a jailhouse informant, requiring disclosure of previous testimony, tracking the use of jailhouse informants so that someone like Leslie White couldn't do what he did, stronger cautions to the jury by the trial judge, but there is no inadmissibility rule. They're still subject to being called, but pre-trial, a tighter grip on who is called. At least that's some movement in the United States. I'd like to talk a little, as quickly as I can, about my own experience. I did call a jailhouse informant just about the time that the controversy was arising in Los Angeles. I didn't know anything about it, but earlier in my career. And then I'm going to talk about 2 Canadian Royal Commissions of Inquiry where jailhouse informants played a major role in a wrongful conviction. In the case that I was involved in was the case of Charles Ng, spelled N-G. The facts of the case are horrible, and that immediately raises questions about the ability to prove it, and pressure from the public and pressure from the media. It was 2 men who went on a spree of rape and murder over a period of about a year. They would kidnap women, take them to a place in rural California where they had built an underground jail and imprisoned the girls and repeatedly raped them, and then when they got tired of them, killed them. It's hard to imagine something more obnoxious than that. They were caught stealing equipment one day. Ng fled to Canada, and the other one killed himself. The coroner and the police combed the area where this jail, the underground jail, had been, and they found bones spread throughout the tall grass in this property. And they pieced the bones together and found 13 confirmed bodies, and then other partial bodies up to around 24. So these two had killed at least 13 and as many as 24. There was a North American-wide manhunt for Charles Ng. He was eventually found in Canada and placed in jail. That's where I came into the picture. I was to handle the extradition hearing in Canada. So you've got all of the normal indicia of a case where a jailhouse informant is probably going to emerge as a horrific case. The public were outraged. There is pressure to extradite him back to the United States. Every time I walked down the street, I had someone come up and say, "Gotta get that guy back. We don't want him here." But the reality was that the case was weak. It was highly circumstantial. And there was only one solid piece of evidence, and that was a videotape buried on the ground showing confinement of two of the girls. And that was it. So the prosecution was solid on 2 counts of unlawful confinement, but that doesn't describe what was going on. It was a serial rape and murder case. Then all of a sudden, a jailhouse informant came along. And he was Ng's cellmate in the Canadian jail. He had a serious criminal record. He claimed that Ng had talked and bragged to him about each of the offenses, right from beginning to end, in detail. Then he claimed that Ng had described individual crimes, then went back to his cell and drew a picture of the crime, hand sketched it, and turned it over to the jailhouse informant, who kept everything. And the jailhouse informant made detailed notes of everything that he heard from Ng. At least he claimed he did. Everything was eventually turned over to the police. I interviewed the jailhouse informant at length. I cross-examined him and I pushed as hard as I could. He was articulate, he was detailed, and he was precise. He looked like my accountant. Sorry, Mike. I asked him why he was making notes, and he said because he was outraged by the enormity of the crimes, and he knew something was going to happen. It would be a movie or a book or something, and he thought maybe he could make some money down the road. I interviewed him several times. The police interviewed him several times. He was unshaken. He continued to be very articulate, detailed, and precise. And his notes were very, very detailed. The drawings were a combination of fact and fantasy, not fancy. I arranged to have a handwriting expert take a look at both the notes and the drawings, and the experts confirmed that the notes had been prepared by him, the jailhouse informant, and the drawings had been prepared by the accused, Charles Ng. So we had some confirming evidence. This is one of the drawings, and it depicts some of the description of the crimes that Ng had given the cellmate, that they were doing the videotaping. The caption above the camera is "Rice is ready, dinner time," building on the fact that he was Asian. And the person on the right-hand side is a fairly good likeness of his partner in crime, saying, "Oh, I love you, Kathy, I really do," and whipping her. The videotape does show a whip. And at one point he pulled it out and he said, "Either you cooperate with us or I'll give you a very firm beating right now." So this picture that we knew was prepared by the accused and was in the hands of the jailhouse informant, we know that that was actually prepared by the accused. This is a grim picture prepared by Charles Ng. I told you it was basically a case of bones in the grass. This is a picture of Boyd Stevens, who is the coroner, and he's holding bags of bones containing the remains of each of the families. This is the Dubs family. Harvey Dubs, Deborah Dubs, and Baby Dubs. I should have mentioned that 2 of the persons killed were babies, which just heightened the enormity of the crime. So you have the Dubs families coming to pick up their bag of bones, and another one in dark clothing, obviously in mourning, taking away the bones of Kathy Allen, above which is remains claiming section. This was, again, a picture or a drawing prepared by Charles Ng. It depicts him in San Quentin in a jail with all of his victims in posters on the wall. And you'll see near on the right-hand side some phrases. One is "no kill, no thrill," and the other one is "no gun, no fun." And it was apparent by this point that one of Charles Ng's strategies was to drag the proceedings out so that he wouldn't be taken back to California. He hoped that by dragging it out, witnesses would die and evidence would be lost, and he could defeat the case by delay. This is an example of one of the pages of the notes. There's about 20 pages of notes, and you'll see the intensity of the notes. One of the things that influenced me was in the notes, there's a reference to this. He said, you can even hear the handcuffs clicking on the video. And this video that was found in the ground, buried in the ground, showed that one of the girls had been confined using handcuffs. And you can hear the cuffs clicking. It's quite, as you know, it's a unique sound, and you can hear it clearly. The point is that no one would have known about that in the disclosure package, wouldn't disclose that. It was not a fact in the media. It was not out there publicly. So how did the jailhouse informant become aware of the fact that the video showed handcuffs and you could hear the clicking? And the only answer is he got that from Ng. That suggested to me that he was telling the truth, despite the fact that he was a jailhouse informant. Then the question is, should that person be called? And we had great debates on that. On the argument in favor of calling, the notes played heavily on that because they were so detailed. This is often the jailhouse informant will say, yeah, he told me he killed her with no details. This was far from that. It was highly detailed. The interviews that we had of the jailhouse informant, he was unshaken and detailed. And as well, he was able to piece the puzzle together right from beginning to end in a way that no other evidence was able to. The arguments against calling him are the obvious. He had a serious criminal record, and his motives in making the notes were, I thought, a little unclear. He claimed that he saw money down the road through a movie or a book. Maybe that was true, but I called him, and he was on the stand in cross-examination for 2 weeks. Every detail on his criminal record was examined, excruciatingly detailed. He emerged from the witness stand after 2 weeks unshaken. The backstory to the case was after Ng was returned to California, the Americans wanted to call him as a witness because they had come up and watched him testify. And one of the assistant district attorneys said to me while he was in Canada, he said, I watched him testify. He's as good a witness as I've ever seen at any point in California. He was that good. So they wanted to call him, and he died in a car accident before the trial, so he wasn't called. Just very quickly, I'll take 30 seconds to outline what happened. The case continued to be paper thin the American prosecutors weren't sure that they were going to get many convictions, despite all of the work that they had done on it, and they lost their star witness. What's going to happen? And Ng made a huge tactical error. He insisted on testifying. It was not a case where the accused should testify because you would be crucified in cross-examination by the prosecutor. But he took the stand, and all that the prosecutor did was he would pick up the first drawing and say, "Did you prepare this?" "Yes, I did." Exhibit 1. "Did you prepare this?" "Yes, I did." Exhibit 2. He got all the drawings in without having the jailhouse informant to testify. And Ng was convicted on all of the counts. Now, I'm starting to run out of time. Let me really quickly try to skate through this public inquiry into a case called Morin. Again, a 9-year-old girl was killed. It was razor thin, public outrage. 2 jailhouse informants were called as witnesses. DNA showed that the accused ultimately was not guilty. DNA, it exculpated him totally. And this is what the commissioner said at a public inquiry into what happened in the case. He said, "In custody, informers are almost invariably motivated by self-interest. They often have little or no respect for the truth or their testimonial oath or affirmation. They may lie or tell the truth depending only on where their perceived self-interest lies." A second public inquiry involving the strangulation of a 16-year-old girl. Again, same sort of thing, public outrage, paper-thin case. 11 inmates put up their hand and said, "The accused confessed to me." 11! In a paper-thin case, so the prosecutor said, "Okay, let's select the best ones." So they selected 3 and called the 3. All 3 lied. The commissioner, who was called at a subsequent public inquiry into what happened, said that one of the 3 that was called had heard more confessions than many dedicated priests. He had made a business of claiming that he heard confessions. That's how he got out. Here's what the commissioner said about jailhouse informants generally, and I put it out there because these comments are equally applicable in New Zealand. They are the most deceitful and deceptive group of witnesses known to frequent the courts. The more notorious the case, the greater the number. They rush to testify like vultures to rotting flesh. And that's the headline in one of the newspaper articles on the table over there. It was picked up by a reporter. They're smooth and convincing liars seeking something and should be removed from our trial process. That was said by the commission, who is a retired judge from the Supreme Court of Canada with a tremendous reputation for moderation, I should say. He was a very gentle, moderate man, moved to make comments like this because of how he felt about jailhouse informants. There was a culture shift that took place in Canada, and I'll just take maybe 1 minute to try and summarize it, because that is the best way to deal with this. The culture shift that took place moved prosecutors to change their approach to cases, moved the police to change their approach to cases, and then the police at a very senior level decided that they were going to adhere to this movement, this culture change, to the point now where, at least when it comes to jailhouse informants, they're not called. Nobody believes them anymore. But it took 18 years for the culture shift. That experience then wound its way over to Australia and has been noted by the Supreme Court of New Zealand in 2011 in the Hudson case. The current situation in New Zealand is that jailhouse informants' evidence is admissible Despite all of the concerns, there are several options available to New Zealand in my view. I do want to cover this because it's important to end my comments on a concrete note. The first option is to maintain the status quo and caution the jury in a fairly general way. I don't think that that's a viable option, by the way. Increase the level of warning, that's a better option. Presumptive inadmissibility of the evidence, but 3 decisions from the Supreme Court say no, that's not an option. The 2 most viable options in my view are tough prosecution guidelines, but the prosecutors have to buy into that, and I'm not sure if they are, but tough criteria that dictates when you call and when you don't, or the nuclear option, which is to legislate when jailhouse informants can be used. That, in my view, is the preferred option, but it's not for me to act on. That'll fall to government in New Zealand and the public. Those are the 2 options: clear, public, and narrow prosecution guidelines concerning use, and failing that, legislate use and warning. Here's the path forward, I think, that I would recommend for New Zealand. This could either apply to guidelines, prosecution guidelines, or legislation. First of all, a clear statement that the prosecution should not call jailhouse informants except in the most exceptional circumstances. A screening committee decide not just one person. Too often, the prosecutor who's invested in the case wants to call everything that he can get his hands on, or her. It should be a group of prosecutors that look at it critically. A publicly accessible registry of all decisions taken by the screening committee, a written agreement with the witness, disclosed to the defense before the trial, and tendered in evidence at trial, so that you know that there was a deal with the jailhouse informant, and here's the terms of the deal. And the defense can use that in cross-examination. The police should record all contacts with the jailhouse informant, interviews, informal interviews, and have that available for the defense. And assign a prosecutor not previously involved in to conduct a fresh eyes review. If you're going to call a jailhouse informant in one of those exceptional cases, a maximum of 1, because if you call 3, a jury might say, well, there's 3 of them. There must be something to this, when in actual fact, each one is unreliable, and 0 plus 0 plus 0 is still 0. I would recommend that the case not proceed if the jailhouse informant is the only evidence that the prosecution has. And under no circumstances call a jailhouse informant convicted of perjury unless the confession was recorded video or audio. And as well, I would suggest that it be required that the Solicitor General file a certificate confirming what benefits have been conferred on that witness. And he or she would need to canvass all of government, all departments of government, because those benefits can arise all over the place within government. So a certificate from the Solicitor General saying, I've canvassed governments generally, and here are the benefits that have been extended, or there were no benefits. That completes my presentation. I'm sorry I ran over just a wee bit. Please forgive me, but I really appreciate being invited, and thank you for your kind attention.